Good morning and welcome to the First District Court of Appeals. And I want to put out a special welcome to the students who are here from NKU. We have two cases to be argued this morning. The first one is Green v. Peters. If the attorneys could please rise and identify yourselves and your readiness to proceed, please. Thank you. Okay, thank you. Next we have In Re R.H.
Norman Wessels on behalf of the state of Ohio, the appellant. Proceed.
Thank you.
Good morning, Margaret Kane on behalf of the appellee, RH, ready to proceed.
Okay, thank you. I will be using the lights for time, which is on the podium. Green means go, yellow means you have about a minute left, and red means that your time has expired. If we could get the first set of counsel up, please. And you can get started, Ms. Fleming, whenever you are ready. You can come on up and get started whenever you're ready. Would you like to reserve any time?
I'm looking for the green light.
Oh, sorry, it's actually on the podium.
I see it.
Okay.
And thank you very much for the opportunity to do our oral argument here. And
Would you like to reserve any time, ma'am?
sure, my name is Roseanne Fleming. I'm representing Mr. James Christopher Green. And regarding I would like to begin with an opening statement regarding a little of the background, which I refer to wholly in terms of his affidavit. The affidavit is attached to document 2, TD2, and it wasn't filed separately. It was filed with the complaint of tortious infliction of emotional distress. The affidavit begins with a
And I don't mean to interrupt you, so you have 15 minutes. You have 15 minutes to argue.
Yes.
If you want a rebuttal time, you need to reserve how many
May I
minutes
have
you would
3
like?
minutes rebuttal?
Yes.
Okay.
And so I just want to begin with an opening statement saying that this case actually was an accusation for assault that happened on September 24th, 2021. It went to court in August 4th, 22, based on an accusation of assault that failed the first time around, which was on September 24th. There seemed to be no harm to the complainant. She said there was a red mark, but the police couldn't find it. Blue Ash
When you say it
police.
failed the first time around, you mean when the police officers showed up,
When the police officers
responded,
showed up on
they
September 20th.
decided not to charge at that time?
That's right, Your Honor.
Okay.
And as time went on, the next day, Miss Peters, the plaintiff here on Blue Ash, said that had developed some photos, 5 photos, I believe, and they showed a progressing red mark on her chin, and the police accepted these photos as new evidence. And that evening, or the following evening, picked Mr. Green up, took him to their jail, photographed him, arrested him, fingerprinted him. The case went to court, and when the damages could not be proved, there were no damages. A testimony had been given at the scene by a witness that there was no assault. She said she stood between the two, and there was no appearance of assault.
And I don't think we have that in our record. I think what we have is that it was dismissed, but we don't have the details
It
of what
was
happened
dismissed.
at the trial court.
Yeah.
So
It was
I would
dismissed.
say, why don't you try to focus on what we have in the record
Sure.
And we're actually quite familiar with the facts, so if you want to save that time and get to your arguments.
All right. So the reason I pointed to the affidavit was the question became whether or not there were sufficient facts in order to justify a trial, I suspect, by the court in the appeal that I made on behalf of Mr. Green. The word belief has a lot of time spent on it in the documents that you have reviewed. The word belief has two definitions. One given by
Counsel,
the Oxford.
could I help focus your argument here in terms of the two specific deficiencies that the trial court found? So, number one, it found intent lacking, and number two, it found outrageous conduct lacking. Do you have any case law that helps support your argument that the filing of a false police report constitutes outrageous conduct?
May I back up a little bit in
Sure.
terms of your question, Your Honor? Your question, I think, first of all, addresses, I'm sorry, it was a two-part question, I think. Could you repeat it, please?
Sure. So the trial court found two parts
Yeah.
of the IIED test lacking on the four corners of the complaint. First, intent, and secondly, outrageous conduct. And let's maybe zero in on outrageous conduct.
Well, may I answer the first question first, the intent? I used the document called Law of Torts. And the writer of that, I think his name was Winford, defines what I think we need here in order to figure out whether or not the woman's actions showed intent and whether those actions were something she desired. I believe her actions showed intent because Mr. Green was...
Even if we agree with you that her actions were intentional, what about the outrageous conduct piece? Because your adversary has cited quite a lot of case law suggesting that the filing of a false police report does not rise to the level of outrageous conduct. Can you walk me through why you believe the opposite?
I can, Your Honor. I think there are two reasons. Number one, if I recall directly, the response to my complaint for Mr. Green by the attorney for Miss Peters. That was they were in that rebuttal for Miss Peters. The attorney made the point that this was not intentional, that we couldn't prove that it was intentional on the part of Mrs. Peters. Her conduct shows, and I think that fits the testimony in the law of torts, that the conduct of the person, that she wants a certain thing to happen, suggests what her reason was for committing the so-called charge, making the so-called charge. The conduct that Mrs. Green showed was she did all the movement here. My client was on the sidewalk. She crosses the street from her house where there was noise being made. That's all my client could tell me. He said, I know there was noise across the street. She walks across the street, somehow or other fell in the grass, and then starts to yell, assault.
We're required to limit our inquiry to the four corners of the complaint. We have to look at what's spelled out in the complaint that was filed.
Well, is the affidavit acceptable as part of the complaint?
It is, but can you identify for me how this rises under the law to
Yes,
the
I can.
level of outrageousness?
I can, Your Honor. I think I've quoted rather extensively the City of Columbus versus Fabish. And in that case, there are many, many other cases quoted, partly Ohio law, partly other federal law. If you look, and I think we have to look in today's society, at the situation, the cultural situation, use of the N-word, which she had done about 2 hours just ahead of time and within the year. So she had 2 times called or used the N-word, as my complaint states, against this family and against my client. Once for himself, once for his mother. When that happens to a person that's a black person, the cases that I read that were attached with and referred to in the city of Columbus showed that things were, the use of that word was despicable. And I think that was the words that I grabbed hold of. That the use is despicable because of the history in this country in terms of slavery against the blacks. Can we forget that? My reply brief says, in this case particularly, the family had endured.
So it sounds to me that what you're arguing is that it's not just the filing of the false claim, that there's more that was within the 4 corners of the complaint.
Yes.
That support both intent and outrageous conduct, right?
That's right. That's
So
right, Your Honor.
So part of it is the use of the N-word, right?
Yes.
And what else would you say is within the 4 corners of the complaint that is more than the filing of a false claim?
There's more than the filing of a false
Right,
claim?
that there's more at hand, more behavior.
Well, what happened was, as a result of the use of the N-word twice, plus the false claim, I wouldn't deny the false claim, it was a reality. There was a reality that happened. Not only was the case dismissed, but there was a reality that Mr. Green lost his job because of a duplicate requirement that he had to go through for fingerprinting at a new client's, a new workplace.
So you're saying that because he lost his job, that is supportive,
The
that
loss
the
of the-
false claim was outrageous
The
conduct?
loss of the job, and particularly the kind of job that he liked, which was care of the ill, he felt that it took him 4 months to get a new job, and he didn't wind up at the new job, at a health place.
And as I recall, the false claim was an assault, was it not?
False claim was an assault, yes.
Okay. Now, within the complaint, you have this language about submitting contrived evidence to ensure arrest.
Submitting what?
About contrived evidence to ensure arrest. That language is found within the complaint. Are you familiar with what I'm
Yes,
referring
yes.
to? Okay.
Yes.
Do you want to speak on that? Does that add to?
Well, my understanding of the law is that you, in order to get privilege, that's what brought that up, in order to be protected by privilege, what you say to the police or what you give to the police, you have to do it for legitimate and legal reasons. I don't think there's any legitimate or legal reasons for the actions other than to satisfy the intent that was leading this woman to show her disregard and unhappiness with people of different color moving into the neighborhood. They lived on the same street, about a half block difference. She's on one side, he's on the other side. That I think it was one of the problems, one of the big problems.
Counselor, if you would like to reserve 3 minutes, your time has expired.
Thank you.
Thank you.
Do I hit any of these buttons?
No,
Okay.
no, I got him up here, thank you. Mr. M, whenever you are ready, I'll start your time.
Thank you, Your Honors. Ready to proceed? May it please the Court, Ms. Fleming. First, although I have to just spend a moment stating that although I understand Your Honors have to accept as true the allegations that are contained within the four corners of the complaint. I just wish the court to know that Ms. Peters adamantly and categorically denies any use of the N-word in any allegation.
And if you don't mind speaking up, because we really would appreciate the students being able to hear you.
Oh, absolutely, yes.
Thank you so much.
And welcome, everyone. So I think I can be very brief here, Your Honors, because I believe the case law is foursquare in favor of the decision that was made by the trial court here. We have cited the court to numerous cases that show that the filing of criminal charges, even if they are not warranted, does not rise to the level of extreme and outrageous conduct.
Well, counsel, what about the argument that there's more here? So all of those cases say just the mere filing of a false police report without more is not outrageous. But there's an allegation here that there is more because the pictures were faked, the N-word was used, et cetera. Can you address whether that's sufficient to elevate the conduct to outrageous status?
Well, the first thing I would say, Your Honor, is that there's certainly no case that's remotely on point that would support those allegations. I understand every case is different, but counsel has not cited us to any case law with any similar set of facts that would support a finding of IE.
Agreed. That's why we're here.
Yeah.
What is the more, do we have any indication from case law what more means, what the more is that courts are looking for?
Not that I could find, Your Honor. Not that I could find, and certainly not under these circumstances. I know that Your Honors are well familiar with the fact that the standard of extreme and outrageous is very high, and it involves conduct that's way beyond what we would consider to be tolerable in a civilized society.
Which is very interesting, the argument that's forwarded this morning in oral argument of looking at it within the context of social norms.
Yeah. It is an interesting argument. I would cite the court or remind the court of the Jamanchuk case, or I'm sure I'm mispronouncing it, but it was a case, Your Honor, involving an employment situation where a person of Polish extraction was subjected to, according to the complaint, to 10 years of derogatory statements about his ethnicity. And the court found that that did not rise to the level.
Now, was that a case that went to the merits at the trial court level and then went on appeal? Or was that a case in summary judgment?
I apologize, Your Honor, my memory may be leaky here. My recollection is that it was on summary judgment.
Yeah, because I think one of the nuances of this case is that it is a 12B6, and it's such a low threshold to get within the four corners. And if there's no case law to point to that we can say, as a matter of law, this isn't sufficient, it's sort of hard to say that it doesn't pass that such minimal threshold.
The 12B6 threshold is a minimal threshold, Your Honor, but the IIED threshold is a very high one. And I think we do, ever since this tort was originally recognized in Ohio, we've seen, of course, countless cases where IIED claims have been made, and we've gotten a very clear picture of exactly how high that threshold is and how extreme and outrageous the conduct must be.
And I think that's the interesting tension that this case presents, because the 12B6 is such a low threshold, the IIED is a high threshold, so should it survive the 12B6? Perhaps it won't survive summary judgment, perhaps it will, I don't know. Perhaps it will survive on the merits, perhaps, right? So that's sort of the interesting tension that this case presents. So what would be your best argument as to that it should not survive 12B6?
Well, to begin with, the focus of the allegation in the complaint is that a false police report was made. And the case law is very clear that that in and of itself does not constitute extreme and outrageous conduct, and courts have had very little difficulty in batting down those types of cases. What do we have in addition to that? Is the more that Your Honors have been referring to this morning? Well, we have the idea, the notion that there was a contrivance of evidence. Well, Your Honor, in every single case of filing a allegedly false police report, there's a contrivance of evidence.
Well, this is
right?
a little different, because I think it's not just the contriving of evidence, it's the pursuit, the continual pursuit of the false charges, in essence, what's being alleged by the complaint. So it didn't survive the original contact with the police officer who responded to the call, right? There's what's intended to be presented as a neutral third-party witness who didn't witness the assault at the moment that it occurred, and then the contrived evidence and the pursuit of the arrest after the first one failed. So that's sort of an interesting twist that I'd like for you to address.
I think if the allegations in the plaintiff's complaint are to be believed, then the very original report of an assault was a contrivance on the part of Ms. Peters. So what's being alleged here is that the whole thing was contrived.
But there's the second part of the statement, because it says contrive evidence to ensure arrest. So there's I think the insurance given, the facts giving that, again, it failed on the first contact. Then there's a contrived evidence to try to get the arrest despite the failure on the first contact. And that's really what, this is notice pleadings. This is what the notice is being provided to the defendant on the four corners of the complaint.
Correct. I would have to say, Your Honor, that I have to disagree, that in any case of a false police report, you're talking about contrived evidence.
I may agree with you on that, but what I'm saying is in this case, you don't have just a police report with contrived evidence. You have a pursuit of an arrest in addition to the contrived evidence.
Yeah.
In other words, more than one pursuit.
Well, I mean,
Which is a little different than the cases that you're citing.
It's a little different, but I don't think it's meaningfully different.
Okay.
I don't think it's meaningfully different. And when we talk about the use of the N word as a way of sort of, I guess, trying to dress up or improve the allegations, what was alleged was a single use of the N word by my client toward Mr. Green. Not that, counsel cites to the case of Columbus versus Fabridge. First of all, that was a criminal case that the court was addressing involving an allegation of disorderly conduct. Secondly, it involved repeated utterance of racially charged language that the court held could constitute the offense of fighting words in the particular context of that case. So that was not an IIED case. It did not.
Counsel, is there any IIED case law with regard to use of racial slurs?
Yes. Yes.
What does it say?
Well, that was and again, I tried to practice this name several times before my argument, but I'm still missing it. Jakimchuk, I believe, is the case that I've cited, Your Honor, and referenced earlier in my argument, where 10 years of derogatory ethnic slurs and intimidation was alleged on the part of an employer against an employee, and the Court of Appeals in that case found that did not reach the level of intentional infliction of emotional distress. So at the end of the day, what we have here is a claim that is based primarily upon an individual being accused of an assault that he says he didn't commit.
Mr. M, can I redirect you for a moment? So In the court below and to our court, you argued an alternative basis for the dismissal. The one I'm interested in you addressing is the statute of limitations. In what circumstances would the statute of limitations become shorter in an IIED claim? I mean, and could you also explain how this particular case fits that definition?
Yeah, the argument we made, Your Honor, was that this was really a defamation of character claim that was dressed up as an IIED claim. We argued in the court below and alternatively here that the allegation in its essence is that my client made a false statement that damaged the reputation of the plaintiff, Mr. Green. And courts have held that if the essence of a claim is more in the nature of defamation of character, even though it's called IIED, you have to consider it for statute of limitations purposes as a defamation claim. And of course, here, the claim was filed more than a year after the alleged defamatory statements were made.
I have a question with regard to that. Were you required to file a cross appeal in order to properly advance that issue?
I don't believe so, Your Honor. I didn't do so, so I hope I was not required to do so.
It seems as if you're changing the nature of the outcome of the case, which at my understanding would then require the filing of a cross appeal.
I hadn't considered that, Your Honor. This was an argument that was made in the court below, and we were viewing it as an alternative basis that supported the claim. I didn't consider that.
Because the trial court did consider that argument, did they not, below?
They did.
And made a determination on it. You know, sometimes they don't consider an argument, they only dispose of it on one thing and leaves that open. But in this case, the trial court actually considered it and determined that it was an IIED killing.
That's correct, Your Honor.
I have another question. I want to go back to, and I'm going to try to ask this in a way that's understandable. So if you don't understand, feel free to let me know, okay?
Sure.
For the 12B6, should the four corners of the complaint allege that there could have been an IIED, or does it have to, or should it allege that does it have to establish that there has been an IIED? Do you understand what I'm asking?
Yes.
Okay.
I believe I do.
Yeah, so what is the threshold? Is it that under the facts that are pled, there could be an IIED, or under the facts that are pled, there is an IIED?
I think, Your Honor, the four corners of the document have to allege that there was extreme and outrageous conduct that the defendant intended to cause.
What I'm saying is, does it have to establish, because I think that, does it have to like absolutely establish it, or is it just that there could be and it can move forward to the next phase of the case?
I think it perhaps depends, Your Honor, on the particular element of IIED
Okay.
that you're looking at. But yeah, I think there has to be an allegation that there was severe emotional.
Sure, you have to meet your, right.
Absolutely.
And even though each element doesn't have to be pled with, explicit, precise magic words, but it has to be covered somehow. And what I'm getting to is, does it have to fall into like, okay, there could be, as opposed to, obviously, as a matter of law, if there can't be, then it'll be disposed of at 12B6 and never moves forward to summary judgment.
Yeah, I might have lost the track of Your Honor's question.
It's a very nuanced kind of question, and it's kind of hard to articulate. Because it sounds as if what you're saying is like, look, there's no case law out there that supports this as an IIED, because IIED is such a high threshold, then we should just go ahead and dispose of it now. And it seems as if the plaintiff is arguing like, look, we've covered everything, and, this can be seen as outrageous conduct, this can be seen as, intent, and so that's enough to get us to the next phase.
Yeah, I think,
In other words, let me ask it a different way. Looking at all of the things that are being alleged here, the pursuit of the assault more than once, the contriving of evidence, the use of the N-word, okay? If that could be seen as outrageous conduct, are we good to go?
if it could, you mean if there was a universe in which that conduct could be conceived as extreme and outrageous? No, I think the way the trial court has to examine it is if you just look at the four corners of the document, could a reasonable fact finder conclude from those allegations, if they were proven, that this was extreme and outrageous conduct? I don't think the complaint could survive that.
And we're saying the same thing, and thank you for putting it in those terms. That's really what we're deciding.
Good.
Yeah, so it's not that it absolutely must be, it seems as if, if this could be seen as by a reasonable fact finder. Thank you.
Mr. M., your time has expired.
Thank you, Your Honor.
Thank you. Ms. Fleming, I'm going to give you an extra minute and a half because I gave Mr. M an extra minute and a half.
Thank you.
Counsel, can you address the statute of limitations issue?
Yes, Your Honor, I'd be happy to do that. I really never thought about damages, checking the statute of limitations when I did the complaint. And the reason I did not think about that is that my client asked me to do the complaint for damages. In going back over the materials, the greatest damage that we had, as a result of the accusation, was due to the impact on him. I felt it was tortious, and I renamed my complaint tortious infliction. And I explained in in the original complaint the differences, either negligent or intentional, and moved on. I don't know if that answers your question.
Well, not exactly. So, there's one statute of limitations for negligent and intentional infliction of
Yes, and
emotional
another.
distress, and then another for defamation.
Right.
And your adversary is saying that essentially the complaint that you filed is a defamation claim because you've included some allegations about damage to reputation in the neighborhood and things of that nature. Loss of job because, the employer found out about this allegation and such.
Sure.
And defamation has a shorter statute of limitations that the complaint did not meet.
Yes, Your Honor. And what I wanted to stress is that the real damage here was to my client and to his emotional status.
And how would we know that? Where would we look?
Well, that's just the point. We never did get to discovery. We never really did have any opportunity to unveil the expert's report. When I got the expert's report, I want to assure you, it was that he was suffering from severe emotional damage. I think that is one of the requirements that you look for when you're trying to make a decision between what is tortious here.
But counsel, we're required to look only at the complaint that was filed. We can't consider the expert report in determining whether the complaint meets the standard of 12b-6.
Well, I understand what you're saying, Honor. From my point of view, I felt if we got to trial, we would succeed to that point, but we couldn't get to trial because of the motion to dismiss. Now that, I don't know if you have any further questions that you need me to answer on that aspect of,
No, thank you.
I understand the full, just to finish that up, I understand the full nature that if in fact we had gone with damages, we would have been late to try to prove it because of the statute of limitations. I understand that even if he had intentional motion for even if he had been inflicted with an intentional emotion case, it couldn't have survived because, as I understand the law, if it's damages, it takes over any other tort that might have given an extended time. So, the other thing that was brought up was about somebody from Poland who went through 10 years of suffering from ethnic mistreatment, and that is terrible. I don't think it even equates, though, and applies to what the black people have been through in the history of this country because of slavery and the carry on of that attitude even to today. That the damages that I was trying to get at of infliction at the level at which I was assuming the court might see it was the extent to which people were harmed by the continued use of the N-word.
Ms. Fleming, your time has expired.
Thank you.
Okay, thank you. This case has now been submitted, and we will issue a timely decision.
Thank you.
Our next case up is in re RH, and I'd like to remind counsel not to say the juvenile's name.
I'm ready to proceed.
Okay, you may come on up whenever you're ready. Would you like to reserve time?
3 minutes, Your Honor.
Okay. Gotcha.
Before I begin, I guess I'll give the opportunity for the bench if there's any particular questions that are bouncing around in anyone's head. Not seeing any immediately. I guess where I wanted to start is what I see as a difference between the framing of this issue between myself and the appellee. As I see it, I think there's only one way of reading the court's decision-making process below, which is that there was, at least in the court's mind, a violation of the court's order, and that alone gives it the authority to, as I had presented it in our brief, the ability to rule on this motion to suppress without addressing the merits. In other words, merely by failing to follow the court's order, which is something that we contest, the court has the ability to grant it as a means of, as we see it, punishing the state for failing to follow that order.
Well, could it also be read, I mean, in that order, the trial court said that it had reviewed the motion and that it was detailed, and so, I mean, it was clear that the trial court considered what was in the motion and not just the procedure.
I think it's clear from the record, or at least from the court's filing, that it did read the motion and that it believed it was detailed. This court has already found that a detailed motion alone is not sufficient to put the burden on the state. In other words, I think that at least for motions of suppress under Xenia v. Wallace, this court has said that there is at least an evidentiary burden, that there has to be a demonstration, even in the presence of a well-articulated motion to suppress, an evidentiary burden, that there was in fact a constitutional violation. But ultimately, if
Is that preserved? So did the state raise any arguments going to the burden shifting or the lack of merit of RH's motion below?
I think, if I can just briefly address Judge Bach's question before getting to that, I think if you're speaking directly about the court's intention and as to why, I think it's fairly evident from her motion that she decided I am issuing this decision as a sanction for failing to follow my order, not based on the merits. Even though she made reference to that there was a well-filed motion, she said pretty specifically, the reason I am granting this is not because I'm addressing the motion, it's because I'm intent on sanctioning the
It
state.
seems as if your argument is rooted in the issue that you raise of being deprived the opportunity of the hearing.
That's correct. I
Okay.
think,
Because I know there's different issues, and I'm just trying to get it down to, it seems that that's really what your argument is rooted in.
right, and
That wasn't a proper basis to deny the hearing. So even if the trial court had considered everything that was presented in the motion and had made a determination on the merits of the motion, that that's separate and apart from whether you were entitled to a hearing. Am I understanding that correctly?
I think so, and I don't want to. I want to go back to what you asked, Judge Kinsley, but I think even if we were to assume that the court had articulated its representation well enough and that the motion of the order was clear, I mean, I think even looking at what the court's intention was on that 13th, she says, like, we're going to have an argument, we're going to have a hearing. She describes it as a substantive hearing. She speculates as to what will happen during the hearing. I mean, to me, it's clear that even if there wasn't to be any facts presented, like let's say, for example, she was clear about that, I still think there has to be a hearing and an opportunity to be heard on the arguments.
What compels that? So I guess, and you asked us at the beginning if we had any questions, and
Yeah.
if I were to ask you one, it would be this. What set of rules apply here? So what rule, from your perspective, would compel the juvenile court to hold a hearing?
I think there's two separate, I guess, what I would describe it as procedural questions. The first is this question of whether or not the court is able to rule on a motion to suppress, which I think is different than other types of motions, without a hearing.
And why is that? Let's drill into that.
Yeah.
This is so important, and I want to
Right.
understand.
I think that if a court intends to do that, if a court wishes to rule on a motion to suppress without a hearing, I think that that intention needs to be made explicit in the absence, I guess, of party agreement. I think that the court has to make sufficiently clear to the parties that not only am I requiring briefs, the reason that I'm requiring briefs is because my intention is to rule on this in the absence of either both a hearing or oral arguments at all. I think in
And
this.
where does that come from? I mean, I understand the
Yeah.
practicalities of why you would say that, but is there a case or rule or something that compels that outcome?
I'm basing it off of case law that I think interpret Juvenile Rule 19 and I think Criminal Rule 47, this idea that a court has general control over the way that it handles its motions. I think entwined in all this is also the idea that a motion to suppress, at least under Xenia v. Wallace, has a specific burden that is placed on, as I see it, an evidentiary burden that is placed on the defendant that I think doesn't fit neatly into the juvenile or criminal rules. And I think that's kind of the second prong of what I was getting at, which is
So we
ultimately.
kind of intuit our way to this outcome?
Sorry?
We intuit our way to this outcome? Because, I mean, the rules are kind of clear in a very general way that courts can dispose of motions without hearings, in a very general way.
Correct.
And then it's your position that maybe that isn't so true with regards to motions to suppress, because there's some evidentiary burden that could, depending on the circumstance, be on either party.
I think the way that I read Xenia v. Wallace, and I have to go back in to look at the specific rules that they follow, but I think the criminal and juvenile rules are set up in such a way, they mention something to like where other rule does not apply or where it's not in contrast with the already determined law. And I think the law is determined, at least under Xenia v. Wallace, does require there to be some amount of evidentiary burden on the other party. Now, I guess there is a.
There's plenty of case law that motions to suppress can be summarily denied without a hearing.
Right.
That's clear. So why is it different when motions to suppress are summarily granted?
I think the issue is specifically at least generally in motions to suppress, or maybe more specifically with this case, there's an allegation of a specific constitutional violation that's being alleged. And I kind of placed this in the rest of my memorandum, that what you're talking about, I think dismissal of the entirety of a case with no more than a simple allegation that is not borne out by any sort of evidentiary, without getting to the merit of it.
And this is part of my concern. This is a big ruling you're asking us to make, that there always must be evidence in support of any motion to suppress, right? That's what you're asking us to hold.
as I read the Newell case and the difference between the Newell and I believe the Watt case that this court has already put out, I believe that there is already a determination that there is at least a burden that is placed on the moving party defendant to bring that forward.
It's your position then, because in this lineup of orders, what I see is that the state was ordered to file a written response, and that there was going to be a hearing on March 27th. And from what I can tell, that looked to be like an oral argument type hearing, not a, bring in your witnesses type hearing. And so if that had played out in the ordinary course, where the state had filed its response in writing on March 22nd, and everyone had come in and orally argued on March 27th, it would then be your position that the trial court could not have granted the motion following that hearing, right?
I think that part of, so you're saying if, at least just so I understand the hypothetical, where the state had filed in a thing and they had shown up and not done a substantive hearing, but only done the oral argument.
Right.
I think a written argument that this would, I think, presume that the written argument that the state put forward would have conceded that there was at least a constitutional violation, which I think the state can do. If the state had submitted something in writing and said, we are conceding the fact of a constitutional violation, we're going to stipulate to the facts that are within that motion, and here is the law that we think is relevant, and we would like the court to consider that. I don't think that in that circumstance that an evidentiary hearing would be required. I do think that,
Well, I guess here's the trouble I'm having, because at no point leading up to that March 27th hearing did the state say, we need witnesses, hold on a minute, that the motion had been filed, everyone had seen it, and the state didn't say, we can't just do this on paper, we've got to have evidence.
And I think the reason for that is because the intention of the court was fairly clear that there was supposed to be a hearing. I mean, I think pointing back to what the court said.
And on that response, I want to focus on this case.
Yeah.
So I want to move away from the idea of making a general statement and just say, okay, in the circumstances of this case, was it improper for the trial court to proceed on the determination of the motion without a hearing? Okay, so that's,
Sure.
I'm just giving you the basis of my questions, then, all right?
Understood.
So when the state showed up for the March 27th court date, I'm going to call it the court date.
Sure.
What was the expectation of the state as to what was to occur that day?
My understanding is based on what the court had said previously, so I understand. So I'm trying to focus on just the facts of this case.
Thank you.
The court had said previously that there was going to be a hearing just on the motion to suppress that day, although they left open the possibility of possibly going to trial that day.
And
Now,
where are you rooting that from?
the fact that, I know that at least, if I'd have to look back at the transcript, but I do believe the officer was subpoenaed and present. I don't remember if that's in the transcript or maybe that's in the entry from the court. But in addition, I can point specifically on, I think it's on the 13th transcript.
Because on what I see is the 13th entry, okay? And it says, continue to 3/27/2024 at 10:30 for motion to suppress and trial,
Yeah, right.
right?
The court on the.
So it says for motion to suppress and trial,
Right,
right?
right. I think if you look on in the transcript, on page 6 of 13th, I know my time has run out, if the court will allow. We'll have the hearing following that week, which means that no response, the response is to be filed. We'll just have the motion and the hearing and the arguments, and then we will plan on having trial after that date. But we can also talk about it if something during the motion makes us think that's not a good idea.
So it seems to me that the record is showing that there was a hearing to be had on the motion that day.
And I believe that is consistent with the actions of all the parties. Again, I do believe that the court had brought in the officer for the purposes of having a hearing on that motion in accordance with what the
So
court
that
had said.
almost gets to whether it's a proper sanction to say, we're going to have a hearing, or no, we're not, because you didn't file a response to the motion. Because getting back to Rule 19, which is cited, it's, the court may make by provision, by rule or order for the submission and determinations of motions without an oral hearing. So that would require, it seems to me, the bench to make an order prior to the 27th. And it seems as the record establishes otherwise, not that there was an order saying, oh, we're going to do this without a hearing, or even if you don't submit a motion, we will not have a hearing. It's quite the opposite. It seems as if the record is establishing that there was to be a hearing that day.
And that's part of the argument for the state as well, that I think goes to both questions, that the state, at least from the entry, I think was sparse, but at least from what the court had told the prosecutor on the 13th, there was an intention of the court to have a hearing on that day. Whether it was oral or not, I think there had to have been that hearing.
And you know, proper sanction, I mean, I don't even want to get into that in detail, but I'm assuming that if the state had been held in contempt, that perhaps the state would have licked its wounds and accepted that,
I can't speculate as to what
as opposed to having them, you know, that possibly could have been a proper sanction.
I don't know. I at least that seemed to be where the court's head was at, but obviously the prosecutor didn't go through with the contempt hearing. All right, I'm out of time.
Thank you.
All right. Good morning, Your Honors. Margaret Kane on behalf of the appellee, RH. So I'll pick up where we left off with Juvenile Rule 19. So Juvenile Rule 19, as well as Criminal Rule 47 and Civil Rule 7B2, are analogous provisions which allow for a court to make a determination on a motion without a hearing under certain circumstances. Now, the state did cite to one case out of the 3rd District, Etzler, State v. Etzler, where the court did in fact interpret the language of Rule
Well,
19.
doesn't that case write out the or order part of Rule 19 in effect? I mean, that limits it to local rules only, and it eliminates the option of an order for dealing with motions.
Right. And so that is exactly what Etzler does. And I will say that Etzler is actually the outlier. There are numerous other cases of courts interpreting the language of those 3 analogous provisions to mean that as long as the opposing party is given an opportunity to respond, that a court may choose to rule on a motion without a hearing.
Is that what they're standing for, or is it that the court may put on an order that there will be a decision without a hearing? And that's where I'm trying to, you see what I'm saying? Because I
Sure.
think there's a difference of saying, oh, we're going to have a hearing. Oh, no, we're not. I'm going to sanction you by granting this motion absent a hearing, as opposed to saying, okay, I'm going to make a decision without a hearing, and I'm going to put on this order, and everyone has the expectations, because then at that point, the state would probably submit an affidavit of the officer, you know, the things that normally would be vetted out would be then done via attachments and that sort of thing, right? Because there's not going to be a hearing. So are those cases saying, oh, the court can just, you know, at any time forego the hearing without notice, or they're saying the court has the authority to put on an order?
So those cases are dealing with slightly different factual circumstances. It most commonly comes up in instances, for example, where a motion to suppress is filed and, 24 hours later or 3 days later, the court issues a decision without giving the state an opportunity to file a response. So in those cases, the appellate courts have explicitly acknowledged that the lower court does in fact have the authority to go ahead and issue without an oral hearing, but the central question in those cases was, did the court, prior to issuing this decision without a hearing, did they give the state an opportunity to respond? And in this instance, it's very clear that the state not only had an opportunity to respond, but it was actually ordered to respond in writing. It's also clear from,
And even if I agree with that, okay, would you say that responding to a motion would be different than responding to a motion in which the party knows that there's not going to be a hearing that will be had? Wouldn't that response be different?
the response, I imagine, will be different. But I think in this case, what the issue is that, and I think this is evident in the record, that the court ordered a response in part because it had, in reading the defense motion, had found that what was alleged on its face was sufficient to grant a motion to suppress, ordered the state to respond.
Where are you getting that part that it was sufficient?
So that is based on the court's decision ultimately to grant the motion to
Right, but
suppress.
that's after the fact.
That is after
That's
the
not,
fact.
that's,
So,
because it seems I hear what you're arguing, which is that the court put on an order saying, hey, state, and it says must respond to the motion by 3/22/2024. Must. So the court put on an order directing for the state to file that motion by a certain deadline. The state did not comply with that, right? That speaks to me of contempt.
so I think.
Do you understand what I'm saying?
Yes, I do. And I certainly see that angle of it, and I think that there is perhaps an element of that. But additionally, the juvenile rules do provide that when there isn't a specific rule that is addressed by the juvenile rules, that the court is to look to other provisions for further guidance about the appropriate next steps or the appropriate way to proceed. And so,
But that brings us to Rule 19, right?
yes.
And so this is what I really need help with. Rule 19 gives the authority for the trial court to make provision by rule, which I think everyone agrees that there is no juvenile rule. In
Correct.
this case, that applies. Or order, right? So if you can direct me to where that order is, okay, that would have been in effect before we get to March 27th.
Well, counsel, is there such a requirement that the court give advance notice? I mean, I think the state wants us to read in this requirement that they be told ahead of time.
Well, I want my answer on the order because I'm really struggling with that.
So
So where is that order?
sure. So I think there are two pieces. So one, the rule is not clear about whether or not that order is something that's to be given in advance of the hearing, that, we are asking that both parties submit their written arguments in this motion will be decided without a hearing. Sometimes that does happen, but the rule doesn't actually require that prior notice to the parties that that is what's going to transpire. Now, I think, and in the cases that have interpreted this, out of multiple districts, both under Criminal Rule 47 and under the juvenile rules, it is clear from those cases that the courts weren't as concerned about the lack of there being a prior notice to the parties that was how it was going to be disposed of, but rather the fact that the state or the opposing party didn't have an opportunity to respond. In this instance, I think that it is the fact of the state's failure to respond that obviated the need for the hearing, because by not responding, the state failed to take its opportunity to tell the court why it was that they believed that the evidence should not be suppressed. And in doing so,
I understand.
I think in the court's view,
Thank you for responding to my question. I really appreciate that.
And so in this instance, I will briefly address this, but the state, by not responding, failed to put forth any facts or legal arguments as to why the evidence should not be suppressed. When it came to the point of the day of the hearing. And in fact, there was a hearing. It ended up not being a substantive hearing on the motion, though the state was given an opportunity to move forward with a show cause, which would have given them time to be able to proffer some of these arguments, and also an opportunity to explain to the court why it was that it did not file its response as the court had ordered it to do. And so I will say that I do think a lot of these arguments are waived as they were not raised prior to the filing of the appeal, despite the fact that the state had multiple opportunities to raise them, even if it was in an admittedly tense situation. So in this instance, the RH filed a factually and legally detailed motion to suppress, which set forth.
Before you go on, something you just said sparked something in me. Did the state at the March 27th hearing, did the state have the opportunity to seek a continuance or to ask for more time to submit something in writing?
So the state could have requested a continuance. They didn't. The court had actually acknowledged that they could have requested a continuance. The court did address the fact that had the state requested a continuance, she would have denied it, most likely, because the child, RH, was in detention. This case had been pending for quite a long time. The state had not complied with the order, had not requested additional time.
Well, counsel, wasn't there the insinuation made, I think there was a finding to this effect in the final order that the state represented to the court that it just simply didn't file written responses in these circumstances?
Yes, so in the decision, so the entry granting the motion to suppress, the court did indicate that. I think one of the challenges in this case is that it appears that there were some off-record conversations that, you know, obviously this court can't consider because it's not in the record. But yes, the court indicated in her entry, the judge indicated in her entry that the state's only reasoning for not filing was that they don't usually file one. And I will note that in the transcript from the hearing from March 27th, the prosecutor did in fact acknowledge that it was his understanding that he was supposed to file a written response. And that was on page 4, I believe, of the transcript. Now, I want to just circle back a little bit to touch on this idea that the defense is required to adduce evidence as part of its initial burden for a motion to suppress. Now, one of the cases that the state really focused on in its brief was this court's decision in State v. Newell. And in State v. Newell, it is true that this court ultimately held that it was improper for the lower court to grant a motion to suppress where the defendant hadn't reached or hadn't satisfied their initial burden. However, that case involved a motion to suppress that was far less detailed than the motion to suppress that's at issue here. This motion to suppress articulated both facts and law and how those two things come together to establish that the statements and any evidence coming from those statements needed to be suppressed under both the federal and Ohio constitutions. In State v. Williams, which came after, which is a 7th District case, the 7th District distinguished that case from Newell, and part of the basis was that in Williams, the defendant, in their motion to suppress, had articulated the very facts on which the court was to rely on to determine the motion.
Counsel, in these cases, had the state preserved an argument that the defense did not meet their burden? Like, were there merits-based arguments that were sorted out in these cases?
So in Newell, Newell was, I believe, the motion to suppress was granted without a hearing and without any evidence, and so the state in that instance had not put forward any argument, but the court had found that on the face of its motion to suppress, there was not enough detail in that. And so this court had indicated, you know, if the defendant had called the police officer to the stand and cross-examined to establish that it was warrantless and to establish some additional facts, then it could have been granted. Or put the defendant on the stand to testify to those things. In Williams, on the other hand, there was enough evidence already within the motion to shift the burden to the state. And that's what happened here. And that's why it's so significant.
Your time has expired. If you'd like to take 20 seconds to wrap up.
Yes, so we would just ask that this court affirm the juvenile court's decision to grant this motion to suppress. There was substantial evidence that RH's rights had been violated. The state had more than ample opportunity to respond to the motion to suppress and also to raise some of these arguments at the hearing on March 27th, but they declined the opportunity to have a show cause hearing, and they also declined the opportunity to proffer any arguments opposing this motion to suppress. So we would ask you to affirm.
Thank you.
Thank you.
Mr. Whistles? I'm going to give you 2 minutes. She went over about a minute, so I'm going to give you 2 minutes.
Okay, thank you, Your Honor. If I can just, I want to reference something that opposing counsel had referenced, which was the state's, I think it's framed almost as a concession in their memorandum of what the state said. On page 4 of the 27th, the prosecutor says, Your Honor, I was under the understanding that we were to respond in writing to these, and then it cuts off. So I think, as I see it, the prosecutor was attempting to explain his understanding of the court's order. I think it's disingenuous to disregard that the court cutting him off as like some sort of concession of the state. And I think that's ultimately, there was some talk about whether or not the state could have or should have requested a continuance in this matter. I think what the record makes clear is it was the court's intention to have a contempt hearing based specifically on what the prosecutor did or did not do in relation to failing, allegedly, to follow this order. So I think probably in consideration of the prosecutor's rights, I'm sure him choosing not to answer and risk being held in contempt should not be held against him. I do believe the issue was properly preserved for this appeal, and that reflects in the entry of the court. I think ultimately, though, and I think maybe this goes more to what Judge Kinsley, what you were saying about what it is the court or what the state is actually asking for here. I think to the extent that opposing counsel and I agree that there has to be an opportunity to respond, what opposing counsel referred to as a substantial opportunity. And to the extent that the rules are designed to give both parties an opportunity to respond. As I look at the record, at least of this case.
Isn't the question slightly different here, though? Because it seems as if the state was given an opportunity. I think there's some debate about what that opportunity was. Clearly, there was some opportunity given.
Right.
And the larger question is, what is the power of the court to move forward in a particular direction when the opportunity is not taken?
I would phrase it, I understand the court's reasoning. I would phrase it as this. I think that at least what is clear from the initial record of the court, which was that it expected a written writing and it also expected there to be an oral hearing. I do not believe the court had the ability to pull away that opportunity, that other opportunity of that oral hearing based on the failure to provide. In other words, I do think that the court, even though it's not well reflected in its entry, I think the record does make clear that the state was going to have an opportunity to respond, if not in writing, then at this oral hearing.
So is the remedy then, from your perspective, to remand the case so that the state can orally argue? Because that's the thing that it was deprived from doing?
At a minimum, I would think so, because what I was getting to is that even if this court were to determine that the opportunity was properly set upon the state, or that the order was properly granted, I don't think anything that the state did absolves that trial court from having to respond to the merits of the argument, something that I think it denied the state the opportunity to present any sort of argument to. Even if we take all the facts in consideration, that lower court did not make any determination as to the merits of the motion to suppress, which I think it had to do. It would be the same thing here. If I were to fail to follow a brief, this court could not say to me, you know, only based on your failure to file the brief, we are going to grant
All
it.
right, so perhaps two remedies from your perspective. One being redo the order and make some merits determinations, and then part two, have an oral hearing because the state was not able to meaningfully participate in that way.
Correct. I think this court's, I think, as I see it, it's going to depend on how the court determines it or interprets the entry of the trial court. But I think, as I see it, to me, the only two decisions this court could do is either remand it and say, by failing to follow it, the state has waived any determination on the facts, but has to be given the opportunity as to argue the law of the case, or to completely remand it to give the state the opportunity to respond in writing.
And so I'm clear, the remand for the redo the order piece, that comes from case law in your perspective.
Yes.
And the oral hearing piece comes from Rule 19.
If I understand correctly, I think that's a correct statement
Okay.
of my position.
Thank you.
Thank you.
Thank you.
I have one question based on that, because I had not thought about the question that Judge Kinsley asked, and then your response, your very thoughtful response to that. With regard to remanding, and I'm not even sure I fully understood, remanding so that that we can say, okay, it would be remanded, and the state would not be able to provide facts? Is that what you were saying, right?
I think at least as I understood Judge Kinsley's position, and I
Okay.
could be incorrect here, if this court were to determine that, at least as it relates to if the court were to, I think as I understand it, agree with the appellee's position that by failing to file a written response, the state has at least in some way waived its ability to contest that burden of, as we see it, of a constitutional violation. It would be sent back, at the very least, for a state to have that burden having been conceded, the state to present its own argument as to the merits of, you know, that burden has been met. What does the law have to say about those facts and evidence? I don't want to. I'm not exactly sure where the Judge Kinsley's head is at, but that's where my understanding of my interpretation
Yes.
of her question.
I
don't know if that
understand.
answered
I
your
appreciate
question.
that. I really
Okay.
do. Thank you so much.
All right,
Right,
thank you.
Thank you.
This case has now been submitted, and we will issue a timely decision. The students who are here, if you could just stick around in the courtroom, and we'll be back in a few minutes to talk to you.